Mr. President, Your Honors, as legal representatives, excuse me. Your Honors, as legal representatives of Mr. al-Nashiri, referred to by the court as LRV3, we have been filing our written submissions together with 3 other legal representative teams who have been referred to by the court as LRV2. We maintain our position presented in these submissions, and we join the arguments presented by our colleagues during today's hearing. I wish, however, to make a few remarks concerning ground 4 of the LRV's joint appeal, concerning the pre-trial chamber's determinations of the court's jurisdiction over the crimes committed as part of the U.S. torture program. I will try not to repeat the submissions that have been already made before the chamber today. However, I will try to focus on specific aspects that are of particular importance to our client. Mr. President, Your Honors, we submit that the pre-trial chamber prematurely and erroneously excluded from the court's jurisdiction criminal acts arising out of the U.S. torture program, including crimes committed against Mr. al-Nashiri. We submit that these determinations should not only be considered as affecting factors that the pre-trial chamber took into account in assessing the interests of justice. Neither can they be described as mere obiter dicta. Had the pre-trial chamber decided that the investigation would serve the interests of justice, its remaining determinations on jurisdiction and admissibility would remain valid. Your Honors, the pre-trial chamber's erroneous determinations that were clarified to you from our reading by my colleague, Ms. Reich, were categorized by the pre-trial chamber as determinations concerning territorial jurisdiction of the court. However, the reasoning of the pre-trial chamber shows that in reaching these conclusions, it had conflated material with territorial jurisdiction. As noted by Ms. Reich, it erroneously restricted the scope of the application of Common Article 3 of the Geneva Conventions to the non-international armed conflict in Afghanistan by limiting its application only to the territory of Afghanistan. The appeal brief of Office of the Prosecutor explains in detail these failures of the pre-trial chamber, and we join this argument and support it. The pre-trial chamber disregarded the fact that the crimes in question have a cross-border and continuous nature, that their individual elements cannot be considered separately, in isolation, without warping the picture of the crimes and victimization of Mr. al-Nashiri and many other victims of the U.S. torture program. Your Honors, I will focus my further remarks on the pre-trial chamber's determinations concerning the link between the crimes committed as part of the U.S. torture program and the conflict in Afghanistan, as well as on the continuous and cross-border nature of these crimes. Your Honors, the pre-trial chamber made its determination on the link between the crimes committed as part of the U.S. torture program and the conflict in Afghanistan in part of the impugned decision titled Territorial Jurisdiction. The pre-trial chamber found that the link between the crimes of the U.S. torture program and the armed conflict in Afghanistan can be determined based only on the location of the acts of capture. This means, according to the pre-trial chamber, that torture of Mr. al-Nashiri does not fall under the court's territorial jurisdiction because he was captured in Dubai. For the pre-trial chamber, it is irrelevant that he was then transferred to and tortured in multiple state parties to the Rome Statute, specifically Afghanistan, Poland, Romania, and Lithuania. This determination is legally erroneous. The link to an armed conflict is one of the material elements of the war crimes of torture. The factors that are to be taken into account in assessing this link have been explained in the jurisprudence of the Appeals Chamber in the Antaganda case, in the judgment referred to by my colleague Ms. Reich. This judgment refers to the well-established factors that were noted in the ICTY judgment in the Kunaraj case. Your Honors, these factors include whether perpetrator is a combatant. They include assessment of whether the victim is a member of opposing party or a non-combatant. They include and necessitate assessment of whether the act which was committed served ultimate goal of military campaign. These factors include also assessment of whether the armed conflict played a substantial role in the perpetrator's ability to commit the crime. These factors do not include location of the crime or of its mere antecedents, as the acts of capture are referred to by the pretrial chamber. Your Honors, interestingly, the pretrial chamber makes reference to the paragraph of the judgment in the Antaganda case, which lists those factors. However, it fails to take them into account. Your Honors, we submit that had the pretrial chamber applied the correct factors to determine the nexus element, it would have determined that there is a reasonable basis that acts of torture in question fall under the scope of the court's jurisdiction. It would have determined that the acts of torture committed under the US torture program towards Mr. al-Nashiri and other victims would fall under this court's jurisdiction. Your Honors, I will turn now to the pretrial chamber's limited and erroneous understanding of acts of torture committed as part of the US program. Your Honors, it is unclear why the pretrial chamber, in its assessment of the court's jurisdiction over the crimes of torture we focus on, why the pretrial chamber focuses only on the location of the act of capture, the mere antecedent, as the chamber refers to this act, of the crime of torture. As I noted earlier, it is not a factor based on which one can determine whether a nexus between acts of torture and the armed conflict in question exists. If singled out, it is also irrelevant when assessing territorial jurisdiction of the court over the act of torture. This is because the acts of torture committed as part of the US torture program are not single, separate acts. Yesterday and today, we have heard detailed descriptions about the acts of torture that the pretrial chamber excluded from the court's jurisdiction. These are acts which are continuous crimes. Mr. al-Nashiri was captured, transported multiple times to different locations, not knowing where he is going, for what purpose, and for how long. In each of these locations, he was held in incommunicado isolation. His torture started with his capture in late October 2002 in Dubai and continued for almost 4 years through Afghanistan, Thailand, Poland, Morocco, Cuba, Romania, Lithuania, Afghanistan again. Since September 2006, he remains a prisoner in Guantanamo Bay military prison without access to any effective remedy to seek justice. His torture, illegal and incommunicado detention continued for years and crossed multiple borders, along with his forced and extralegal transfer across those borders. To understand the complex, continuous nature of torture and ill-treatment committed as part of the US torture program, it is important to refer here to the background paper on CIA's combined use of interrogation techniques of 30th December 2004. We refer to this paper in our joint brief in footnote 201. The paper explains that effective interrogation is based on the concept of using both physical and psychological pressures in a comprehensive, systemic, and cumulative manner to influence high-value detainees' behavior, to overcome a detainee's resistance posture. The goal of interrogation is to create a state of learned helplessness and dependence. The paper explains that the interrogation process is broken into 3 separate phases: initial conditions, transition to interrogation, and interrogation. Initial conditions phase consists of capture shock, rendition, and reception at black site. The paper states that capture is designed to contribute to the physical and psychological condition of the high-value detainees prior to the start of interrogation. Your Honors, based on these descriptions, it is clear that the US torture program was intended to conduct continuous torture over detainees. A correct assessment of the court's jurisdiction requires taking into account the entire system of abuse and crimes as an organized and connected set of criminal actions conducted against Mr. al-Nashiri, but also against many other victims over many years and across many borders. Your Honors, the pretrial chamber in the Bangladesh situation has determined in its recent decision on the prosecution's request for a ruling on jurisdiction under Article 19.3 of the statute that the court's jurisdiction is engaged where at least one element of a crime occurs within the territory of a state party. It is our submission that the chamber erred in its determination of the court's jurisdiction over these crimes, completely disregarding the continuous character of the crimes in question. As noted by my colleagues, the US torture program was designed in a way to avoid any jurisdiction, to avoid accountability. The pretrial chamber's muddled determinations with regard to the court's jurisdiction over the crimes committed as part of the US torture program are not only unclear, but they are also legally flawed. Unless corrected, they will result in impunity. Thank you, Your Honors, and with your permission, my colleague, Mr. Mikołaj Pietrzak, will take the floor. Thank you.
Mr. President, Your Honors, as my esteemed colleague Maria Radziejowska explained, failure to change the decision of the pretrial chamber, not merely with regard to the interest of justice argument, may leave Mr. al-Nashiri and other victims of the extraordinary rendition and enhanced interrogation techniques torture programs outside of the scope of the investigation with no remedy, no effective investigation, no accountability. We reject the idea that any effective investigation could have, can be, or will be conducted by the United States of America authorities. As counsel for LRV2, Ms. Catherine Gallagher has just said, the identity of the perpetrators of these crimes is well known. We know who created and administered the torture program to Mr. al-Nashiri and other victims. They are Mr. Jessam and Mr. Mitchell and others. If there was any will on the part of the US state, they could have already been arrested and charged. They could be arrested today. This has not taken place, and it is painfully obvious that it will not take place unless this court authorizes an investigation encompassing these crimes. The issues raised by the impugned decision and connected with the Group C questions, in particular regarding nexus-related issues which have already been addressed today, and the potential to leave behind victims of the extraordinary rendition and enhanced interrogation technique or otherwise torture programs, require that we address the statement made today by the representatives of the Afghan state. Even though there are no grounds to do so, if we do, in a gesture of sheer optimism, believe that the Afghan state, which has failed for so long to investigate effectively, can and will now investigate, failure to authorize an investigation by the appeal chamber to be conducted by the Office of the Prosecutor on the grounds of complementarity would lead, at best, to an investigation regarding only a limited group of victims represented before this court. Those who were victimized only in Afghanistan in the very narrow territorial scope of the conflict in Afghanistan. However, any investigation by the state of Afghanistan would not and could not address the crimes committed by the victims of the torture program created by Mr. Jessom, Mr. Mitchell, and the CIA. This would leave behind Mr. al-Nashiri and other victims of the kidnapping, rendition, illegal, multi-year imprisonment, and torture at the hands of the CIA and actors of all the states, including Rome Party states, who cooperated with this agency. We ask that the appeal chamber change the decision of the pretrial chamber and authorize the investigation. We ask that the appeal chamber do so in a way that leaves no doubt that the grievous crimes committed against Mr. al-Nashiri do not fall outside the scope of the investigation. Any other decision will leave Mr. al-Nashiri without justice, the truth of his suffering untold, his rights and freedoms unvindicated, with no chance of an effective investigation and no perspective of accountability for the perpetrators of the terrible crimes he suffered. The decision of the pretrial chamber is legally flawed, unjust, and if left unchanged, will result in impunity and injustice. Thank you.